actual presentation. It was really interesting, and sorry I have to rush because it's really late. So I have the pleasure to introduce Mr. Wang Jing. The pronunciation is correct. Welcome to Italy again. He's director of the China Maritime Law Association, arbitrator of the China Maritime Arbitration Commission. He has substantial experience in dealing with matters relating to bill of lading, charter parties, marine and non-marine insurance, P&I defense, the rest of ships, and many other items. I leave to you the time to speak about your work and your experience. Thank you very much.
Thank you. And good evening, ladies and gentlemen. And I'm honored to be invited to this conference, and also thank you for your patience to spend so much the whole day. And I will thank Francisco for invitation, and so that I have this opportunity to discuss with you about the recognition and enforcement of foreign arbitral awards in China, and share with you my thoughts on some issues. My speech today will discuss the legal basis for the recognition and enforcement of foreign arbitration, the arbitral awards in China, reviewing applicable convention, laws, and judicial interpretations. After a brief of the documentation required when applying for enforcement of a foreign arbitral award, it will consider grounds for refusal and strategies to overcome such objections. The cornerstones of China's system for recognition and enforcement of foreign arbitral awards remains the country's accession in 1987 to the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, usually referred to as the New York Convention 1958. Every award made by an arbitral tribunal in a country contract to the New York Convention shall be principally be recognized and enforced in China. For some other territories which are not party to the New York Convention, special mechanisms like bilateral treaty or the principle of the reciprocity will be needed. The Civil Procedure Law of China prescribes that all the applications for the recognition and enforcement of foreign arbitral awards shall be filed to the People's Court at intermediate level in the jurisdiction where the party subject to enforcement is the domicile or where the property to be enforced is located. The law gives the courts 2 months to review and examine the application, and if the award is recognized, enforcement should be under normal circumstances, be completed within the 6 months from the ruling of recognition. For the usual document necessary for commencing recognition proceedings in China, you may refer to our handout, which contains the more details. The handout is available in the register desk. As the system approach to avoid local protection and to ensure due compliance with the New York Convention, the Supreme People's Court in 1995, issued a notice to set up a system to regulate lower courts and recognition and enforcement cases. We usually refer to this as the internal approval procedure. Here, if an intermediate people's court, in China also there is a maritime court. By the way, in the Chinese court system, maritime court is on the same level as the intermediate people's court. Intend to reject an application for recognition and enforcement of the foreign arbitral award. Before it makes its ruling, it has to make a detailed report to set out in detail the application, now what the arguments are advanced by the parties, what are the costs, the intended grounds for the rejection of recognition and enforcement, and then seek approval from its upper court. That is a higher people's court on the provincial level. Whereas the higher court also considered the rejection to be justifiable, it has to further submit its separate report, setting out its own reasoning and seek further approval from the Supreme People's Court. It's only when the China higher court approaches the rejection can the ruling by finally make. It looks like complicated. That's even though no appeal is allowed for the ruling on the recognition and enforcement of arbitral awards. We can see that in China, every decision for rejection of recognition and enforcement is actually reviewed by the higher level in the judicial system. The grounds for the refusal and recognition strategies. When reviewing an application for recognition and enforcement, the People's Court will follow the Article 2A3 of the Civil Procedure Law, which mirrors the Article V of the New York Convention. In order to save time, I'll omit the article in detail. Alternatively, the People's Court also has the right to examine whether Chinese law permits the subject matter in dispute to be settled by arbitration and whether the foreign arbitral award violates the China's public policy. On the grounds that the People's Court may refuse the recognition and enforcement as well. For years, the People's Court have been applying a stricter approach to the statutory grounds for refusal. Furthermore, the adopted system of report and approval position the Supreme People's Court as the gatekeeper in valid decision to reject the recognition and enforcement. As a result, the rate of the recognition of the foreign arbitral award in China is very high. On average, there are more than hundreds of the applications every year for recognition and enforcement of the foreign arbitral awards in China. Most of the applications are approval, and according to the cases published by the Supreme Court. In the past 10 years, there were no more than 20 cases where recognition and enforcement were refusal. In our experience, the two objections in particular are frequently raised against the recognition of a foreign arbitral award. One common strategy is to argue that the arbitration agreement or the arbitral clause is invalid under applicable law. The law that designates in the arbitration agreement, or if there is no such law, then the law of the country where the award is made, or if failing the laws that mentioned above, the law of the foreign. A second often heard argument is that the party against which enforcement is invoked did not receive the notice of arbitration or was otherwise unable to present its case. For example, because it was granted in sufficient time. That is most the reason the other side and argue about it. It will give an example to show the Chinese court's approach to such issues. In the case that Donovan S.A. sued against the Huafeng Group of China, is a case in 2006. In this case, the applicant present the original contract, which contained a clause the rule and arbitration Liverpool. Given that both parties had not agreed on the applicable law, the court confirmed the validity of the arbitration clause applying the law of the country where the award was made. The Arbitration Act 1996 of England, also having invoked experienced China lawyers at an early stage to ensure that the necessary evidence is collected and well prepared in advance of the application for recognition and enforcement in China. The applicant was able to present satisfactory email and courier records, providing that the notice in arbitration were well received by the opponent. Finally, the court recognized and enforced the arbitral award. Due to the time limit, I could only give an outline the speech on the above the issues. I hope to similarly more than values the discussion on this topic. For your issue reference, we have also prepared the handout, which is available. Okay, thank you.
Thank you, Wang Jing. One curiosity is that whilst it is possible to enforce an arbitration award issued in London in China, a judgment of the English court is not enforceable in China because there is no reciprocal agreement for the enforcement of judgments. And this became quite relevant when a lot of the shipbuilding contracts were made, and the refund guarantees in those cases often provided for the jurisdiction of the English High Court, which meant that if a judgment was made under the refund guarantee for payment to the buyer, that judgment could not be enforced in China. So for a long time, we were explaining to people that in refund guarantees, the usual English High Court clause was not appropriate. So that's one important lesson that was learned from our greater knowledge of enforcement in China.